cour.
Thank you. Mr. Fader?
Chief Justice, Justices, I want to begin with two preliminary points about what is and isn't an issue in this case. The first point is this: Mr. Wall does not challenge the substance or merits of the Judicial Committee's disfellowship decision. He does not argue that its decision was wrong or unreasonable or not based on the evidence or inconsistent with religious doctrine or custom. He does not argue that the Judicial Committee judged him to be insufficiently repentant for his sins. That is not the principal dispute. Nor is he asking this court or any other court to determine who is or can be or should be one of Jehovah's Witnesses. He's also not asking any court to inflict some enduring association with Mr. Wall on the Jehovah's Witnesses. None of those are his arguments. The only argument Mr. Wall makes is that the procedure followed by the Judicial Committee was flawed. It breached the requirements of natural justice imposed at common law. He was denied procedural fairness. To use the Chief Justice's term, he is not asking anybody to be a super rabbi, or in this case, a super elder.
So it is a judicial review.
There's been a lot of time spent this morning talking about whether it's a judicial review or not. I don't want to get caught up in the vernacular, in the terminology that we use. He is not seeking the public law remedy of judicial review. It's not an administrative law case. Judicial review in that sense, Justice Wagner, is concerned with policing the delegated exercise of statutory powers for their legality. As we know from cases like Dunsmuir, courts have a constitutional duty to ensure that the executive branch doesn't exceed the powers that have been given to it by the legislative branch. Mr. Wall has never argued that the Judicial Committee is a public authority or otherwise part of the executive branch of government. He has never argued that the Judicial Committee or the Highwood Congregation has statutory powers, much less that they've exercised them or exceeded them.
Then how do we even get to looking at procedural fairness, natural justice, which are legal constructs? If you're not, this is an application for judicial review where we're being asked to examine procedures of a body that you accept is not subject to scrutiny by the state or the courts, and yet you invite us to apply scrutiny to what they do as a freestanding obligation on the part of everyone, notwithstanding whether they're covered by judicial review, to follow the rules of natural justice as developed by the courts. Isn't that the implication of your argument?
I agree with almost all of that, Justice Abella. I wouldn't go so far as to say they're not subject to scrutiny by the courts. What Mr. Wall relies on here, as he did in the courts below, is a long line of cases going back to the 19th century, included in which is not only Lakeside Colony, but Lord Denning's decision in Lee and Showman's Guild, and more recently the UK Supreme Court's decision in Shergill. These are cases that impose a common law, a private law obligation on voluntary associations or domestic tribunals to observe the rules of natural justice when they engage in certain types of decision-making.
Even in the absence of a property or contractual issue?
Well, there is a debate, needless to say, in that regard, and I'm going to deal with it. I accept that under our case law, there is some conditioning of access to that form of procedural review as we've styled it in our factum. I will tell you that if we look at the most recent statement from the Supreme Court of the United Kingdom, that conditioning is absent. But in any event, my client meets the condition. If the condition is, show that this is of sufficient importance to warrant the court's involvement, and I say that is what Lakeside tells us, and I'll tell you also, I have an argument that it's grounded in logic, he meets that condition in any event.
So you're not asking us to change our jurisprudence, you're saying that Mr. Wall comes within it?
Correct.
Okay, thank you.
Exactly correct. With those two preliminary points out of the way, I want to...
Saying that this sufficient importance is independent of any property or civil right? Is that what you're saying?
I am saying that what Justice Gantier says in Lakeside is that the question is, and Justice Rowe took us to the passage in question. He says, the colony conceives of the right one way. The Hofers conceive of it in another way. But whether it's a property or a civil right or a contractual right, it's not so much the question. The question is whether it's of sufficient importance to warrant the intervention of the court.
If it's a property or civil right.
That is of sufficient importance.
The impact of the decision sought to be reviewed, Justice Brown.
That's not how I read it. It says if the defendants have a right to stay, the question isn't so much whether, as the colony saw it, it's a property right, as the Hofer saw it, it's a contractual right, but whether the right, is of sufficient importance.
Right, but the reason in the context of Lakeside that Justice Gantier is looking at the right and assessing its sufficient importance is because it's a right, the ability of the Hofers to stay in their residence, that will either remain extant or disappear, depending on whether their expulsion was valid. And so what he's doing, in effect, is examining the consequences of the expulsion. And he concludes that they are, the expulsion is of sufficient importance, and its consequences are of sufficient importance to warrant the court's involvement. Why? Not because it's a property right, not because it's a contractual right, but because it's akin to the right to earn a living that Lord Denning tells us in Lee and Showman's Guild is sufficient to justify the court's involvement.
I don't want to belabor it, but
Sure.
that's not how I read it. They're talking about, irrespective of how you characterize the right, the question is it's a right. I mean, one does not have a justiciable right to earn a living. I can't go and enforce someone, obtain an order requiring someone to give me a job. It has to be based on a legally cognizable basis, so property or contract, as they identified. Maybe let me be more specific. Can you address the argument that was put to us and that I encapsulated earlier, that really what it is it says the fact that you have a contractual right or a property right is a precondition, but it may not be enough, that it has to be a right of sufficient importance, but it has to be a legally cognizable right nonetheless.
Right, and that's a new gloss to my ear as of this morning from Mr. Nam, and my reaction to it is to say I'm not quite sure what it means. Is a partnership interest a more important right than a shareholding? Is a right to sue for defamation better or worse than a right to sue for a breach of contract? Does it matter what the quantum is? I don't know what to make of that as a concept. The idea that now not only we need to condition access to this procedural review on the existence of a right known to some other part of the law, but now we're going to set up a hierarchy of such other rights, and only certain of them will satisfy the conditioning.
What is your test for sufficient interest? How do we draw the line between, a minor quarrel in a bridge club about who does lunch next time and the case you say should attract the court's attention?
Chief Justice, I say we do it the way the common law has always done it, which is incrementally with reference to the prior cases. I appreciate that you did, and I'm giving you the best answer I can.
Okay, thank you.
Let me formulate an example, if I might, to pick up on Justice Brown's point. If Justice Gantier and the court, because all the members of the court joined in, say current Chief Justice, meant that there had to be, if property read paragraph 9 says there has to be a property interest or a contract interest, and that property or contract interest has to be of significant, sufficient importance. Let me give you an example. In the Hutterite case, there were valuable properties, farmlands and the like, and I think there may have been a patent or something. If there are vestments that go with certain religious ceremonies, and their value was almost inconsequential, just $20 or something, is that not an instance where, yes, there's a property interest, but it relates to something of such modest value that it would be necessary to inquire into, to have regard to ecclesiastical matters to determine the disposition of something which is of very little value versus a share in valuable farmland, for example. Might that be an instance, reading Gantier, Justice Gantier that way?
If that gloss, if I can call it that, I don't mean to use the term pejoratively, I just mean to say it's an additional requirement. If the gloss of importance in the civil or property right is valid, then I can conceive of assessing importance as you propose, Justice Rowe, which is with reference to the quantum of the claim. That is one way of doing it. The difficulty I have is I look at the case law and putting to the side for the moment Justice Brown's reading of the one passage in Lakeside, I see no reference to assessing whether a right, if engaged, is sufficiently important. There's no suggestion that now we have to do this hierarchy of rights exercise, whether by looking at the quantum of damages at stake or something else.
So, just now I'm a bit confused. I apologize. Are you saying there is a two-step requirement? First is a property or civil right issue engaged, and then is it of sufficient importance to warrant the court's intervention? Or are you saying it's not clear that there needs to be an underlying property or civil right?
I'm saying, Justice Avella, there doesn't have to be an underlying property or
That's
civil
what
right.
I thought. So you are trying to get us, if respectfully, to reinterpret what the court said in Lakeside, where it says the courts are slow to exercise jurisdiction in paragraph 6, but they have exercised jurisdiction where a property or civil right turns on the question of membership. And then they go on in paragraph 9 to say the question is not so much whether this is a property or contractual right, but whether it's of sufficient importance. So I don't see anything in the judgment that would allow us to interpret out an underlying requirement for a property and civil right. Now, you may persuade us that there is one, but interpreting the judgment to read out that requirement seems to me to be a stretch.
Right. If you'll allow me, I do have an argument about why looking to a property or civil right, important or unimportant, is not the right way to come at this problem. And if you'll allow me, I promise I will come to it. I do want to put down a marker, though, that if you look to the Supreme Court of the UK's decision in Shergill, it is clear that there needn't be a property or civil right in order to get the type of procedural review that I am speaking about today.
That's why I asked you if you want us to change our jurisprudence. If you're asking us to reformulate the Lakeside test in accordance with the UK Supreme Court, I think that's an argument that I'm listening to with different ears
Sure.
from whether or not you want us to apply our own jurisprudence.
Justice Abella, maybe I can simplify the syllogism this way. I read Lakeside differently than you and Justice Brown. But if your reading is right and mine is wrong, then I want you to change the law to be in keeping with Shergill.
Good luck.
Thank you. I want to turn for a moment to the heft of the appellant's burden on this appeal. Bearing in mind that this appeal arises from a threshold determination about whether the court does or doesn't have jurisdiction even to hear Mr. Wall's allegations, i.e. there's been no adjudication on the merits, and what the appellants are trying to foreclose is any adjudication on the merits. I say that the appellant's burden is to convince you of the following. Where an unincorporated organization, or at least an unincorporated religious organization, makes a decision affecting one of its members, and especially a decision to expel her or him, courts have no ability, no power, no jurisdiction to review even the procedure by which that decision was made. And that is so no matter how unfair the procedure, and that is so no matter how serious the decision's consequences, subject to only one qualification. According to the appellants, the court can review the procedure if and only if some other legal right, which is what we've been talking about, turns on the decision, and if the question of the decision's procedural fairness arises incidentally in some action to enforce that right. And we had some new glosses this morning. We had the gloss from Mr. Nam that it doesn't just have to be a legal right, it has to be an important legal right. And then Mr. Delowitz suggested in his submissions that it's relevant whether the association is invoking the legal right, as was the case in Lakeside, or the member. Apparently it's asymmetrical, that it's important.
And I don't want to put words in Mr. Gelowitz's mouth, but what I took from that was that really jurisdiction wasn't an issue before the court in Lakeside because it had effectively been conceded. That's how I understood it.
And that may be a different way of putting it.
That may be another one of my goofy interpretations.
No,
so
I don't mean to suggest your interpretations are goofy, just that I disagree with them. To put it another way, according to the appellants, it doesn't matter how reasonable and clear the members' expectations about procedure were, it doesn't matter how violently and thoroughly those expectations were breached, and it doesn't matter how badly or extensively the decision has affected the member's life. If the appellant's argument is correct, then as a general proposition, a common law court has no power to do anything in relation to the procedural unfairness of which the member would complain. And that's so despite all of the case law to the contrary, not just Lakeside, but Lee and Showman's Guild and the cases that it cites which go back to before the turn of the
Well,
century.
this is an interesting argument because I thought you told me we were relying on incremental precedent. The cases you cite might one day come before a court, but we are concerned with this particular case, and I think rhetorical statements about what might or might not, what a future court might or might not decide may not be all that helpful.
Sure.
Just a suggestion.
Absolutely. Let me then go straight to the argument put against the case law, and I will deal as part of that with what Lakeside says and what the UK Supreme Court held in Shergill. But what I want to say is, from a high-level perspective, the concern, Chief Justice, that I'm trying to highlight is the potential for serious harm at the hands of religious organizations, not because they're inherently harmful, not because they act maliciously, but because their scope of influence is so large. For many individuals, their religion is their lodestar. It tells them how to view the world and how to interact in it. It tells them what to eat, what not to eat, when to work, when to rest, what occupations to pursue, what occupations not to pursue. And it's that potential for harm that I say the court should have in mind as it thinks about how to calibrate this review. Should it be conditioned on the existence of a property or civil right? Should it be conditioned on the existence of an important property or civil right? Or should it just be available when the impact of the decision is significant?
But Mr.
This is interesting. It's a harm principle, but there are many decisions that cause harm to people in everyday life that the courts would not get involved in. So I understand you're saying this is just part of the context. You should keep it in mind. You're not proposing it as a test.
I'm not proposing it as a test, but I ask you to think about it as we talk about this, because the contention of the appellants is that essentially religious organizations should be left all but alone. In only the most exceptional of circumstances should there be even this mild form of procedural review. And what I want to say is that goes too far. The form of procedural review that I say Mr. Wall is seeking to invoke here is a relatively minor intrusion on freedom of religion.
I'm really interested in this, and you know my dissent in the Lakeside case. What bothered me in that case was how procedural review would really fit in with what was going on. Had they given Mr. Hoffer, I think it was, notice, had they done these things, would anything have been different? It didn't really go to the grievance. The real grievance was, I want to stay in the colony on my own terms, and my fellow brethren want me out. And that had been going on for a very long time. So you apply the legal rules of procedural fairness. You say you give notice, you give a hearing, you do these things. Where does it get you? And more precisely in your case, what does your client, Mr. Wall, think he will get out of procedural review in the legal sense? Can he make the courts make people bring their custom to him? I don't know. Would notice help? Because he was obviously told in their own way that they had a problem, a difference of approach, that they thought he had a problem, more precisely, and there was a hearing of sorts. There was detailed meetings in accordance with the religious tenets, to which he submitted. He had an ample chance to tell his side of the story. And they said, just get over your problem, which is inconsistent with our ethics, and you're welcome back. So what is another layer of legal review going to do here?
Respectfully, Chief Justice, part of the problem is the narrative that you've just given is a narrative that's never been adjudicated upon by any court. There is a dispute about whether the notice was adequate. There is a dispute about whether he understood the procedure, the hearing to which he was being summoned, and the dynamics of it and his rights in it. There is a dispute about whether the committee was properly constituted, whether it was unbiased. And it may be that he has a very steep hill to climb on the merits. But that's actually part of my argument about why we should allow a hearing on the merits. Part of my argument, and one of the points that both you and Justice Gontier agreed upon in Lakeside Colony, is that the principles of natural justice are flexible. They're responsive to context. If the court has a concern about allowing procedural review in relation to religious organizations, I say respectfully that the answer is not to foreclose review altogether, but to ask, to instruct, to hold that it should be conducted with sensitivity to religious freedom, freedom of association, concerns about justiciability, and so on. All of that is legitimate.
Can I? Well, I was going to ask you if, in fact, the significance of the harm is the animating principle that should require a review based on process, on natural justice, why are you limiting it to natural justice? If the significance of the harm is what animates the review by the court, why wouldn't it go to the merits? What is, in your submission, the principle that would limit it to the merits? To the process and not the merits?
The case law and the fact that my client's originating application seeks a review only for process. And it's not a question of first impression.
But that doesn't help us in terms of looking at the coherence of these legal rules, what your client has asked for. So I'm just asking you to help me understand why, if I accept harm as the animating basis for judicial review of these, and I could say review broadly, then why wouldn't that mean I would have to look at the merits?
Well, because there might be countervailing considerations, Justice.
So what are they?
Well, for example, in the context of a religious organization, to review on the merits is to run head first into concerns about justiciability and the application of religious doctrine and potentially contested religious custom.
Again, I just don't understand why what's justiciable would then drive limiting the court to process as opposed to merits. If it's not justiciable, it's not justiciable.
Right.
I'm just not making the connection between the principles you're asking us to use to accept your proposition and how those principles necessarily exclude review on the merits.
Because, and I think the answer, Justice Karakatsanis, is this court could look, as I'll show you in a moment, Lord Denning did, categorically, and say as a general proposition, as an almost universal proposition, to ask that a religious organization's decision be reviewed for correctness or reasonableness is to invite a justiciability problem. Therefore, we will prohibit it categorically and avoid the problem altogether. It is equally open to you, I suppose, to say, confront the problem on a case-by-case basis, and we won't foreclose it categorically. Sometimes we'll allow it. For purposes of this case today, or at least my client's success or failure in this case today, that doesn't have to be decided. But it is open to you to do it. It might be helpful, though, to turn, if you would please, to tab 6 of my condensed book, which is Lord Denning's decision in Lee and Showman's Guild. And in the first full paragraph at the top of the page, he says this. He says, the question in this case is, to what extent will the courts examine the decisions of domestic tribunals on points of law? So he's actually saying this case, Justice Karakatsanis, his case, is similar to the question you're asking me. When, if at all, should a court look at the substance of a domestic tribunal's decision? And he says this is a new question which is not to be solved by turning to the club cases. And then he says this, in the case of social clubs, the rules usually empower the committee to expel a member who, in their opinion, has been guilty of conduct detrimental to the club. And this is a matter of opinion and nothing else. The courts have no wish to sit on appeal from their decisions on such a matter any more than from the decisions of a family conference. They have nothing to do with social rights or social duties. Likewise, might be said that the courts generally have no wish to be involved in religious rights or religious duties. And that's at the center of my submission. But he goes on to say this, and this is the part on which I rely. On any expulsion, they will see that there is fair play. They will not involve themselves in the merits. They will, though, see that there is fair play. They will see that the man has notice of the charge and a reasonable opportunity of being heard. They will see that the committee observed the procedure laid down by the rules, but they will not otherwise interfere. And that's, for purposes of Mr. Wall's case, the law on which I rely. And I highlight for you that it isn't conditioned on the existence of some contingent property or civil right. It isn't conditioned on that contingent property or civil right being an important one. On any expulsion, the court will see that there is fair play.
Let's say, somebody is investigating, one of the interveners, the Church of Jesus Christ of Latter-day Saints. And they've been attending, and they've been taking the lessons, and they've been doing all the readings, and then they get a letter from the stake president one day saying, well, based on some information that we've received, we decided you're unworthy, and you will not be admitted as a member of the church. You'll not be permitted to take in the sacraments. Let's say this is in one of those communities that exist in Canada, which are predominantly populated by members of that church. So there's an economic hit. Where's the dividing line between exclusion and admission, or is there one in your view?
Well, I have three answers. The first is the question doesn't arise here. The second is
that doesn't interest me.
I understand.
We need a general
it interests
rule.
me, but I understand that you are considering other cases, and I want to be helpful to you in that regard. The second answer is the formulation of the right to procedural review that Mr. Wall proposes is one conditioned on a showing of sufficient importance. And it may be that an admission to a voluntary association, even in the circumstances you've described, will never rise to a level of sufficient importance. The third answer is this. The UK cases, including Shergill, premise this jurisdiction for procedural review on the legal construct, the idea that the members have what they call a contract, what they're really describing as sort of a consensual constitution or agreement in the loose sense about how they're going to conduct themselves and the rules that will be followed. If that is indeed the legal construct that this court chooses to adopt, then it seems to me that that construct leads you to say someone who isn't yet privy to that arrangement, that consensus, that contract, cannot seek procedural review for a violation of it. There's a privity problem. I hope that's helpful.
Well,
We often do, we always do say how, not always, often say how important it is for the person who is the target of the concern, that has a right to explain, perhaps to say, look, I didn't do that, you've got it wrong. And I suppose there is some merit in saying due process, natural justice, as opposed to give that person an opportunity either to say, I didn't do what I'm alleged to have done, or, yeah, I did, but there are extenuating circumstances. Members of the congregation, could you please take that into account in assessing whether this is a case for expulsion or not, as opposed to a situation where you just get, without any hearing whatsoever or any opportunity to state your piece, a notice that says you're out with no explanation, no nothing.
And that is the complaint here. The complaint by Mr. Wall, he may complain if he gets a rehearing by the Judicial Committee. First, if he gets an order for a rehearing and then the Judicial Committee chooses to hold one, he may argue that that they have misunderstood what he did, or they failed to consider extenuating circumstances, or they've misjudged his repentance, or they've misapplied religious doctrine concerning what sanction for his lack of repentance there should be. He may argue all those things, but his complaint right now, Justice Moldaver, is essentially the one you've described. He says, I didn't get proper notice. I didn't get a proper hearing. I didn't have a chance to make any of those arguments.
I thought he did, though. I thought he did have an opportunity to appear and speak to the elders and so on. I'm sorry, I may be wrong on that.
Well, whether he did or didn't is clearly in contention, and the problem is, because of the way this case has proceeded, i.e. on a threshold determination of jurisdiction, no court has ever heard him on that issue. There's a dispute in the evidence about whether he was or wasn't afforded procedural fairness. He says he wasn't. The Judicial Committee, not surprisingly, says he was. And all he wants to do is have his day in court so someone can decide whether he's right or they are.
But although there is no decision about, it is in the evidence in the file that there was a notice given, that there was an hearing to which Mr. Wall attended,
Yes.
and that he was orally informed of the decision, and the ground of the decision was his insufficient repentance. The evidence shows that.
Well, sorry, I want to slow down, Justice Cote. If we're going to talk about the evidence, I'd like to look at it, please. The notice is at the last page of tab 3 of my condensed book.
Okay.
This is the notice. Everybody agrees this is the notice. It says, Dear Brother Wall, we request your attendance to meet with the Judicial Committee, not to attend a hearing.
Tab 3?
I'm sorry, tab 3 of my condensed book, which looks like this.
Okay.
Last page. So he's requested to attend a meeting. In the next sentence, the alleged wrongdoing involves drunkenness. Not is drunkenness and only drunkenness. It involves drunkenness. We heard this morning about verbal abuse. It's not mentioned here. The meeting, not a hearing, will be held on Monday, March 24, 2014, 7 p.m. at the Harvest Hills Kingdom Hall Complex. To reschedule for another time, please call Vaughn Lee. We look forward to providing you with whatever spiritual assistance we can. That's it. That's the notice. Now, it may be that when Mr. Wall, if he gets his day in court, a judge concludes that was good enough in all of the circumstances, given what had already happened or given what his expectations about procedure were. I don't wish to try to persuade you that he'll necessarily win. I don't have to get that far. I just have to tell you that he alleges that wasn't adequate. With respect to the reasons...
Sorry. Oh, I'm sorry. If you're still answering the question, I'll leave you.
If I may.
Of course.
With respect to the reasons, there is a dispute in the evidence about whether the reasons given by the committee were adequate. Mr. Wall's affidavit is at tab 2 of the condensed book. And I draw your attention, please, to paragraph 31, which is on the 3rd page. He says that on the above date, being March 24, the Judicial Committee did not state that I was unrepentant, nor explain why they may have felt that I was unrepentant, but instead simply said that I was to be disfellowshipped, publicly expelled from the congregation. Provision of an appeal was indicated. So according to him, he didn't get reasons at all.
Okay, I mean, I had the same kind of question that Justice Cote asked you. When I looked at the factum of the appellant, paragraphs 15 to 20 inclusive,
Justice Bella, sorry.
they set out all of the procedural entitlements they gave to Mr. Wall.
With reference to their own evidence and not his.
No, I know, but even, I mean, if you are right when you say there isn't a biblical way of looking at what natural justice means, did the person generally have the right to know what the case was against him or her and a chance to meet it? It seems to me that what you are asking us for is an even greater degree of procedural entitlement that might even occur in an informal administrative tribunal. Because he knows what the allegation was, he decided not to come to one meeting, he did go to another meeting, they gave reasons, they met for 3 hours, he's told of another meeting, he's told what he has to do in order to avoid the consequences of what their decision is, and then the conclusion is at paragraph 20. So I'm wondering whether, even on the highest standards of procedural fairness, assuming we can get past the jurisdictional argument, even under Shergill, I don't know how this wouldn't comply with what we have said is procedural natural justice in the ordinary courts.
If that evidence is accepted, in preference to Mr. Wall's contradictory evidence, there's a dispute in the evidence about the adequacy of the reasons he was given, about the extent of the notice. If a trial judge prefers the Judicial Committee's evidence to that of Mr. Wall, and if they adopt a relatively restrained conception of the requirements of natural justice, as they may well, then I agree with you. Mr. Wall will lose on the merits.
Was he told that he was to come to a meeting because he'd engaged in the sin of drunkenness? Is that in dispute?
Well, we just looked at the notice, Justice Bella. He was told to come to a meeting and the wrongdoing involved drunkenness.
Okay. And did he ask to present witnesses or not?
His evidence, their evidence is that he did not.
Did he confess to being drunk, as is said? I'm just trying to figure out what is not in dispute and what is in dispute. Are any of these facts set out in paragraph 15 to 20 in dispute?
Well, 15 is a argument.
16, sorry, 16 to 20.
There is no dispute, there may be a dispute about the date. He received a written invitation to meet with the Judicial Committee to respond to an allegation he had engaged in the sin of drunkenness. That is an interpretation of what the notice says, and it speaks for itself, and we've looked at it. The date of March 24 was proposed, but Mr. Wall was given the opportunity to reschedule for another time. True. The elders add, we look forward to providing you with whatever spiritual assistance we can. True. The member has opportunity to present witnesses to speak in his or her behalf. That may be true. There's no evidence that he was told it, which is his complaint. Mr. Wall did not ask to present witnesses. Might be true. May be beside the point if nobody bothered to tell him that was his right. When he met with the elders, he confessed to being drunk on 2 occasions, and on one of those occasions verbally abusing his wife. Mr. Wall did not object to the meeting, the procedure, or any of the 4 elders participating. May be true, but in the absence of any, Mr. Wall's account of this meeting, a hearing, is that he was blindsided by it. The elders provide oral reasons for their decision. There is a dispute, clearly in the evidence. I just referred you to paragraph 31 of Mr. Wall's affidavit, where he says he didn't receive reasons. So there's a dispute there that has to be resolved by someone on the merits if we get there. But
Just trying to understand this. Are you saying because the church itself says we have certain rules that we accept and we adopt and we will apply in cases of this nature, that they cannot now come and say that they don't have to comply with any of that? They never have to. They could just tell the person that you're disfellowshipped, and that would be the end of it. Is your point that because they created their own mechanisms, then he's entitled to have them followed?
Yes.
As a matter of natural justice, due process, call it whatever you want. And his position is, much as they said these things, I didn't get them. Is that basically it?
yes, that is it. And it's consistent with Lord Denning's statement that the court will see that there's fair play. And
Yeah. Apparently, there's some sort of right of appeal, so does he have to exhaust that before he turns to secular courts?
the case law says he does, and the fact is that he did.
Okay.
But just returning for a moment to these passages from the appellant's factum, the significance of them from my perspective is that they actually show that this is a rather pedestrian exercise that Mr. Wall is asking the court to engage in. As it may be an exercise in which the Judicial Committee is afforded great deference, in which the requirements of procedural fairness are minimal, in which everything is sort of scaled back in terms of its onerousness because of the context. All Mr. Wall is saying is, let me have my hearing. I may go in, it may last 60 minutes, and it may be that I'm thrown out and told, nope, that was procedurally fair enough, or I prefer the Judicial Committee's evidence to yours, you lose, you got adequate notice.
How should we answer that plea in cases, and in fact, your friends say this is one of those cases where the process itself is religiously prescribed? I mean, my understanding is that the actual process here included prayer, presumably to achieve some sort of discernment. So, and it makes me wonder whether there is, in fact, a realistic line, as you posit, between procedure and substance. Your submission earlier was, well, you don't go to substance because that's where, that has a religious doctrinal dimension to it. But there are cases where the procedure will too. I mean, the Belgic Confession was mentioned earlier. Well, the Belgic Confession says that disciplinary processes will occur, by the word of God. So what do we do with that?
We do what Lakeside Colony counsels us to do, which is the best we can. We hear expert evidence about the custom, and we assess on an objective basis. It's what the case says, and it's what the Supreme Court of the United Kingdom says in Shergill. Maybe it's useful to turn to Shergill for a moment.
How do we review the discernment obtained in prayer?
Well, it may be, Justice Brown, that the solution to the problem you're proposing, and I agree, it's an obvious problem, is that we simply look to see whether there was prayer as prescribed by custom, and the question of whether the prayer was sufficient or insufficient, and whether the repentance...
We are going to decide if there was prayer according to a custom?
No, I'm sorry. I don't mean to suggest that we're going to describe whether the prayer itself conformed to the custom. We're just going to see whether the custom prescribed prayer, and if so, whether prayer occurred. I can't do better than to say that the court, as with any other case in which the court says there's something here to deal with, whether it be the obtaining of a religious divorce or ecclesiastical discipline, the court, once it's in there, it's going to do the best it can with the expert evidence that it receives about what the custom and tradition is. And it will not apply religious doctrine as such. There is no ability to sue to enforce what one person perceives to be a religious edict and which another person disagrees to be that can't happen. But if there is a basis for being in court in the first place, and I say here is a common law right to procedural fairness, then the court does the best it can as it did in Lakeside. And I don't mean to suggest that it's necessarily easy. I don't mean to suggest that it isn't without its perils, but that's true of a lot of things. The courts across this country do things every day that are hard. They hear expert evidence to help them do that.
Can I take it that you're not arguing here today that the rules prescribed in the handbook, how procedure will be dealt with, that those do not create an implied contract? I haven't heard you talk about implied contract, and there are some written documentation about the process about conduct and the process that's to be followed.
Sure. The best I can do is this. The juridical basis for this procedural review, for the common law obligation to observe natural justice, is in Canada a bit unclear. The cases sometimes talk about contracts, sometimes they talk about property, sometimes they talk about a fundamental rule of law implicit in the realm. And my submission is that at this point it doesn't actually matter, because it's water under the bridge. It's a bit like worrying about what was the juridical basis for the neighbor principle in Donahue and Stevenson. At this point, going back and looking at that is not going to help us very much in deciding what we should do in a negligence case today.
No, but it matters if it goes to the question of whether the court should be looking at it in the first place. And you gave us Shergill.
Yes.
In your factum, you talk about paragraphs 47 and 48 of Shergill.
Yes.
But paragraph 45, and I'm looking at your condensed book,
Yes.
says the courts address questions of religious belief and practice where its jurisdiction is invoked, either to enforce the contractual rights or if it's to deal with private rights and obligations. Shergill, in paragraph 59, again, I'm looking at your condensed book, was about a trust document and who was the beneficiary of a trust. It's a contract case. And what the court says in paragraph 59, if the parties can't resolve the differences, the court may have to adjudicate on matters of doctrine and practice to determine who the trustees are who are entitled to administer the trust. Now, that isn't a breach of what our understanding of when the courts have jurisdiction over religious matters is. It follows what we said in Lakeside. So I'm not sure what you read in Shergill that creates a standalone right to examine the conduct of unincorporated religious organizations to comply with what you say are common law entitlements in the absence of private rights and obligations or contractual rights. I mean, it's right there in 45. It's a trust document.
In a trust document is certainly sufficient, but Justice Abella, I'd like to draw the court's attention to paragraph 46. And I'm just going to read this because I think it's important. The law treats unincorporated religious communities as voluntary associations. It views the constitution of a voluntary religious association as a civil contract, as it does the contract of association of a secular body. The contract by which members agree to be bound on joining an association sets out the rights and duties of both the members and its governing organs. It doesn't say written contract, and there's no logical reason it would have to be a written contract. The courts will not adjudicate on the decisions of an association's governing bodies unless there is a question of infringement of a civil right or interest, not necessarily a legal right.
So you're saying there's a civil right interest, a freestanding common law civil right in all Canadians to have natural justice in every single circumstance.
No, I am not saying that.
Where then do they have it? If we can't tether it to something, then I don't know how we avoid scrutiny of everything in every circumstance.
Well, let's keep reading and maybe we can get an answer from Shergill. The court says an obvious example of such a civil interest is the loss of a remunerated office.
That's a contract.
Well,
Loss of remunerated office is a contract of employment.
of course, yes, agreed.
Okay.
If I can, sorry, just forgive me. The governing bodies of a religious, I'm in paragraph 47. The governing bodies of a religious voluntary association obtain their powers over its members by contract. They must act within the powers conferred by the association's contractual constitution, follow the rules. If a governing body of a religious community were to act ultra vires, for example, by seeking a union with another religious body which its constitution did not allow, a member of the community could invoke the jurisdiction of the courts to restrain an unlawful union. Not unlawful because it violates some other legal right, but because it's inconsistent with the rules of the association.
So does Mr. Wall have a contract with the congregation?
Well, in the British conception, he does, I say.
Does he? Okay, and what's the consideration that flows from him, and what's the consideration that flows back?
Right. There are two answers I can give to that, Justice Brown. One answer is that when we speak of a contract in this sense, we are not importing all of the requirements of the private law of contract, and it is it's just a term being used to refer to a...
So it's not doing any work?
I beg your pardon?
The term, it's not doing any work?
Well, I think it's shorthand for the consensual rules that define the association itself. And whether there's consideration given for them or not is I'm sure that I could devise an argument.
There's a circularity to that, because you're saying really the contract, the terms of this supposed contract simply govern how the contract is administered, but nobody has to really do anything beyond that. I mean, Mr. Wall is entitled to the contract being governed in certain ways, but there's nothing, I mean, there's a certain unreality to this contractual reference, because nobody's having to actually do anything under the contract except administer the contract according to the rules. There's no underlying obligation that you're pointing me to. What does Mr. Wall have to actually do under this contract? What does he get back other than, you know, a path to salvation? Or is that the consideration?
Well, the one obligation of Mr. Wall is to abide by the teachings of the Jehovah's Witnesses, in return for which he gets the continued fellowship of the fellow members of the congregation.
For as long as he wants?
For as long as he abides by the very same constitutional contract.
He can go to the court and say, make an order that they continue to fellowship with me? I mean, I know we're getting into substance there, but we have to take this thing to its end. If that's a contract, then he can go and ask for specific performance. It's not judicial review.
And Chief Justice, that is why it isn't a term that I would use to describe the constitutional consensus that governs and defines the organization, because I think it leads to a confusion in the sense that the case law doesn't support the idea that there's a claim for damages, for example.
Mr. Federt, earlier this morning, there was a reference to the fact that your client had launched an action in defamation for these events.
There was that. It's unknown to me, if so, but I don't have any
Okay, you cannot
basis
comment on that, because I was about to ask you what was alleged in that.
I unfortunately don't have any additional light to shed.
Okay.
Before we leave Shergill, I'd ask, please, that we turn to paragraph 48, which is the paragraph which I most wish to rely. The court says this: similarly, members of a religious association who are dismissed or otherwise subjected to disciplinary procedure, which is precisely what has happened here, may invoke the jurisdiction of the civil courts if the association acts ultra vires or breaches in a fundamental way the rules of fair procedure. And that is not a new statement. That's not breaking new ground. That is just echoing what Lord Denning said in Lee and Showman's Guild about the need for fair play in the context of social clubs, and what the cases he cited had said before that.
So you don't see the beginning of the phrase as being the defining term, that is in the context of someone who's dismissed?
Dismissed or otherwise subjected to disciplinary procedure.
Right, exactly.
The appellants call this a disciplinary procedure. They are clearly disciplining Mr. Wall. Sorry, are we at cross purposes about what disciplinary procedure means?
I don't know if you're making an argument that says you don't need the contractual civil rights or property foundation because of this phrase in a fundamental way breaches the rules of fair procedure. If you are, all I was saying was I had read it as the rules of procedure in the case of people who are dismissed or otherwise disciplined from remunerated employment.
I didn't read it that way. And in terms of the need for a contract, my position remains that in the context of the UK cases, the contract is the association. They conceive of the association as existing by virtue of a compact by the members to come together and associate.
So
under
what do you
certain
say about
conditions.
paragraph 45, which frames the following discussion and sets out the limits? And we consider each circumstance in turn. So they're applying what they set out in 45 as their operative framework, private rights and obligations, contractual rights. They're just elaborating on what they said. They're not creating something new or deviating from it, are they?
Right, but what no, Justiciability, there's no deviation. None of this is new law. But what I'm saying is that the contractual rights of the members are the right to associate with one another. The right, Justiciability, if we look at the second sentence of paragraph 46, it, being the law, views the constitution of a voluntary religious association as a civil contract. That's the contract. We're going to come together and associate under certain conditions.
Contract, this would be a totally different case. Your client could sue for breach of contract.
And Chief Justice, I apologize because I feel as though I haven't been sufficiently clear. The contract is simply the legal or juridical conceptual justification for the rule that has existed in the case law for more than a century. And
If it's a false contract, what kind of conceptual justification does that provide?
well, all right.
I mean, we're talking words here, and
Yeah.
lawyers are very good at spinning words. You're telling us that when the House of Lords used the word contract, they didn't know what they were saying. It was not really a contract, it's something else.
No, I don't mean to say that at all. I just mean that when they used the word contract, they were not importing the entire private law of contract, i.e. the right to sue for damages, or the right to seek specific performance, or a legislated requirement for witness, or that it be in writing, into all domestic tribunals and voluntary associations.
Well, then we'd have to define what the particular kind of contract that applies to a bridge club is.
Right.
And that would be a task for the courts to do in your submission. They would have to create a new kind of conception, which is not like the contracts that apply in commercial matters or other civil matters. So that's really the task you would be asking us to embark on if we accept this on your submission, that it's a special kind of contractual sort of thing.
Chief Justice, I think that's fair, except for the modifier new. I don't think that what I'm asking for in this case is new. I think that the court, if it's concerned with justifying it with reference to something other than the mere fact of precedent, there may be a new concept that has to be articulated. But I don't think the outcome, i.e. a right of procedural review, is new. That goes back to Lee and Showman's Guild and cases from the end of the 19th century.
You know, I guess we're going over ground that's already been tilled, but procedural review is grounded in a certain kind of concept, the rule of law, the control of government, state actors. Is that your concern? That's procedural review. Contractual review is grounded in something else, which is a covenant, et cetera. I won't go into all the details between the parties. So what you're relying on here is doctrine that uses the idea of a covenant, and I'll leave it at that, to give you procedural review. And that's where I'm having difficulty.
Right. And so maybe a different way of coming at it is to say that the law presumes, maybe it presumes irrebuttably, that people who associate with one another and give that association the power to make important decisions decisions that will profoundly affect their life. The law presumes that they have a reasonable expectation that fair procedure will be observed when those decisions are made.
I guess I'm having difficulty with, again, your emphasis on it's the power to make important decisions. And you're doing this, I think, because otherwise we would be dealing with any chess club, any kind of association where there's some set of rules that apply. So how do we draw the line? The Chief Justice asked this earlier. How does the court decide whether it has jurisdiction based on the importance of the impact of the decision?
Justice Karakatsanis, I say it can look to the prior cases. So let's just take two of the prior cases we've been talking about. Lee and Showman's Guild, Lakeside. Lee and Showman's Guild is the right to earn a living, to work, to perform in a particular place at a particular time. Lakeside, rather, is a case about the right to live on colony lands. The Hoffers were residing there. They wouldn't be able to reside there if their expulsion was valid. We can do as we do in the common law tradition. We can look to those cases and say, okay, Mr. Wall has come and he said, you ruined my life. My friends, my family, my customers, they will no longer speak with me. I'm ruined. And a judge, hearing the case on the merits, looks at this and says, is that good enough? After hearing the evidence, says, is that akin to the interest that was at stake in Lakeside or Lee, or is it a lesser interest? And that is what we do already in administrative law in deciding who has an interest, justifying notice and so on.
Thank you very much.
Thank you, Chief
Appreciate
Justice.
your submissions.